Hi, my name is Larry Newman. I'm an attorney located in Ithaca, New York. I recently got a phone call from a woman who had applied for a teaching position, got the position, had filled out all the pre-employment screening paperwork, they did the background check. 9 days into her job, they fired her. And they fired her not because she wasn't doing a good job teaching, they fired her because they found out, or they said that she lied on her employment application. She had, from 20 years ago, a DWAI in New York State, 20 years ago, which is a violation crime. It's not a crime, criminal conviction. On their application, it said, have you ever been convicted of an alcohol offense, drug offense, or sex offense? Ever, and then they gave an area for explanation. But on the second page, they gave definitions of what they considered in that state to be a conviction. And all three examples were criminal misdemeanors. Her particular offense in New York State, a DWAI, section 1192, subsection 1, is a non-criminal offense. It's a traffic violation. It's under vehicle and traffic law. So she was rather surprised. And she wasn't dishonest on her application. And she contacted me because she wanted me to help clean it up. She wanted me to go to the court. I told her, I said, these are the things that we should really do. We should go get a certificate of disposition from the court stating what you started with and what you finished with. Now, she started out with a couple of DWIs, and her final disposition was a DWAI. And that was shown on the certificate of disposition because the DWIs had little M's next to it for misdemeanor, and the DWAI had a little V next to it for violation. So that was pretty easy if you understand the key of what an M and what a V is. But out in the state that she was in, I guess the human resource person didn't know the difference between a misdemeanor and a violation because on her FBI record, which I also reviewed, it just showed operating a vehicle while impaired. And it showed the original offense of the DWI. So they just naturally assumed this was a criminal conviction, when in fact it was not. So she didn't lie in her application. She should have been fired. And what was even worse than all of this was the embarrassment and humiliation that she ended up going through because she needed to contact the parents of all of these children and tell them what had happened, or at least gave her own rendition and then left them to think what was the real reason, you know, because people are always thinking the worst. Is she a level 2 sex offender or something else? So when you're filling out a pre-employment application, you need to be careful if you're going to have any past even DWAIs or any even past unlawful possessions of marijuana, if they haven't been sealed back in the state that they come from, they're going to need to have an explanation. Even a DWI, a misdemeanor, is going to need an explanation. Maybe it's going to need a copy of a drug alcohol evaluation. Maybe it's going to need a copy of the certificate of disposition from the original court. But it's going to need something because you're going to need to give it context, because the name of the game when hiring somebody, giving a certification to somebody, giving a license to somebody, the name of the game is risk management. They do not want unnecessary risk. And so they don't have a negligent hire situation. They have to do their duty, their diligence to do this background check to make sure that a person that they're going to employ or give any authority to doesn't have a criminal past that could cause problems. If you have questions about pre-employment screenings or filling out an application, or you need some help with any of those areas, it's one of the things that I take care of. You can give me a call or shoot me an email. I'll be more than happy to review your situation and see what's needed. And thanks for watching this video.